Once a data breach has occurred and once the data breach has been publicized, as most of the state breach notification laws require, healthcare providers are at a very significant risk of a lawsuit. There is a class of plaintiffs' lawyers out there that have figured out that this field is a sort of a new gold mine, and they essentially hunt for big breaches, well-publicized breaches that they can aggregate a class behind, aggregate a class of affected individuals, and sue the provider. And what they've done is really recreated statutes that were implemented well before the IT era. They find statutes that have a nominal damages provision, a statutory damages provision, meaning a set amount of money given to the affected individual, even seemingly without any harm to that individual. They aggregate a class and they file suit against the provider. Not many of these lawsuits have made their way very far as the courts are concerned, but the reality is that once you're sued, you're sued. You need to defend that action. You need to have the right attorney working on the suit to make sure that it doesn't go far. And it really speaks to the importance of making sure that the front end response, how you investigate and respond to the breach, is done to the utmost standard, because what those plaintiffs' lawyers are looking to do is pick apart your response, say, when you notify these individuals, you notified them too late, or you didn't do this, or you didn't do that. And really, it's essential with that in mind to think about how you choose to respond to the incident, how many resources go into responding to the breach, because ultimately what those plaintiffs' lawyers are looking to do is pick apart your response. The other side of the coin, and these things are not mutually exclusive, is when you have an incident, you've been sued, it's well publicized, you're very likely to get a regulatory investigation from a state or federal healthcare regulator. So the Department of Health and Human Services in particular, and its privacy enforcement arm, the Office for Civil Rights, are very active in this space. They investigate almost any healthcare-related breach that particularly exceeds that 500-person threshold. They're well-staffed, well-funded, and they look to, in some sense, make examples of organizations that do not treat information properly with the proper security channels. Once a regulatory proceeding has occurred, there's always a chance of fines, significant fines, multi-million-dollar fines at times, and equally as burdensome, there are usually lengthy, multi-year corrective action plans, audits, a look into your data privacy perspective and your data privacy security that really would tend to go on even after, years after, the incident itself has faded from the public consciousness.